Well, the Enforcement Directorate is in news for a variety of reasons. It has been in news for various controversies that we have seen in the past. It's an agency that is the prosecuting agency for various serious crimes like money laundering. But recently it dominated news because some senior advocates, reputed advocates from the bar were summoned by the Enforcement Directorate. There were also news that the bank accounts of certain leading firms were frozen by the Enforcement Directorate. Well, that has clearly sparked a lot of criticism on the move by the Enforcement Directorate. It also raises a lot of question about the privilege that exists between an advocate and a client. Talking about this aspect today, we have Senior Advocate Mr. Vikas Singh. Sir, I haven't ever heard of lawyers being summoned for the clients that they have advised. This is clearly a very, very shocking move that came from Enforcement Directorate. But that being said, the powers of ED were upheld by the Supreme Court itself. Were they within those powers or they crossed the line?
So the powers of the ED to summon a lawyer has not been upheld.
Okay.
So the Supreme Court is examining this issue, and today also this matter was listed before the Chief Justice. Now there is a very interesting balance which the court has to maintain, and the balance is that if you see the privilege that a lawyer has of not disclosing a privileged communication, whether it be an advice or whether whatever a client tells him in the course of his engagement, there are two caveats to that. And the caveats are with regard to if the lawyer is involved in the crime itself in some form or the other. I'm just trying to simplify it for you.
Yeah.
So if the lawyer is involved in the crime, then that is not a privileged, then anymore a privileged communication. And the lawyer is bound to disclose. But the real question is that who decides or on what basis the enforcement agency or even the regular police, because the issue is not only of enforcement agency, the reference by the division bench of the Supreme Court is not on the Enforcement Directorate matter but on a state police summoning a lawyer. Who will decide that the lawyer has actually crossed the line and done something himself? Which does not entitle him to claim privilege. So some balance has to be struck. And the balance has to be struck looking at the larger picture, which is that the regular or the indiscriminate or the summoning without any justification will have a chilling effect on the administration of justice. If a lawyer who is representing a person who is in conflict of crime, if he is in fear that just because he's taking up this case tomorrow, he can be called by the ED, summoned by the ED. And if you see the pattern of ED in the recent past, first they call you as a witness. And when you don't answer something to their satisfaction, then you make them an accused as well. So this chilling effect has to not be there, because if you see every client has a right to legal remedy, and he has to be provided legal assistance, and a lawyer has to be also free in giving legal advice to anybody, because that's the mandate of what the lawyer is supposed to do. So the suggestion which I have said, I don't know whether you're aware, ED has after the first summoning come up with a circular where it says that no more summoning will happen of a lawyer without the express written approval of the director of ED. So that's a small safeguard which they have provided as far as the ED is concerned. But this similar safeguard is not there in the CBI or in the regular police. So what I have suggested to the court today is that the ED safeguard, which is of consulting the director of ED, similarly should be there also with regard to the CBI and the regular police. So somebody at a senior level in the organization should be consulted. And the senior officer should have some admissible evidence. And when I say admissible evidence, means that an evidence which will stand in a court of law. So for instance, taking somebody's statement while he's in police custody is not an admissible evidence. Which of course day in, day out police uses while denying bail to somebody. In my view, even that is not correct, but unfortunately today courts accept that for the purposes of denying bail, because they look at the larger picture and they feel that somebody who's done heinous crime and there is no independent evidence so far, they rely on that evidence only for the purpose of bail. But that evidence cannot stand in the court of law when the trial actually happens. So there should be some credible evidence, which is an acceptable evidence in law, for the purpose of saying that the lawyer is actually involved in the crime in some form or the other. And the third safeguard that I have asked for is that this evidence should be placed before the magistrate. And an order should be obtained for the magistrate for issuing the summons, without which there should be no summons. So I think that would be, it's not that we are wanting any special privilege for the legal community, but the thing which is in my mind and which I argued today also was that if this is not done, then it will have a huge chilling effect on the legal profession.
Because, sir, this time the names that were summoned by ED were big and very respectable, well-known names. But you might have young lawyers who are advising some companies who might be under the lens of the Enforcement Directorate, and they might face similar problems. So there is a need to put an SOP in place. But there were arguments that were advanced today by the learned Solicitor General as well. How did you find the view of the state on this matter, or the agency in this matter, which is a party?
So the agency today was very cooperative, and they said that we are not, there is no adversarial litigation, and we also agree that this is a good suggestion. But they, as of today, I don't know what they'll do on the next date, but as of today, their solicitor and the attorney said that we only want that this kind of a safeguard that you provide should not be misused, to which we don't have any objections. Obviously, what checks and balances could be put in the safeguard is something which they probably will come up with on the next date, and we'll get some guidelines. I don't know whether you're aware, in the for medical professionals, this happened, that when consumer forums started taking all kinds of cases against doctors, and doctors' relationship with their patient is very similar to a lawyer's relationship with his client. As far as the professional part is concerned, it's a relationship of trust, and you go on that trust to that doctor, and the doctor ultimately tries to do whatever according to him is the best. And if he were to face criminal cases or even medical negligence cases in the routine, he will also be wary of taking any, I would say, bold decision on the basis of what, in his view, without a test could be a proper course of action. So the Supreme Court provided in that Jacob Matthew judgment that before any case is to be registered, it has to go to a committee of doctors to say that there is a negligence. Now that was a safeguard which was felt to ensure that the medical profession is secured. So I think a similar safeguard will be required here. And here we have a statutory protection. It's only a matter of how to ensure that the statutory protection is not violated by misuse.